Greetings, and welcome to the fifth and final video in the Elder Law and Guardianship Training video series for attorneys. Our final video focuses on matters that occur after adjudication, such as navigating client administrative duties beyond the hearing, guardianship monitoring by counsel, and review hearings. These items are addressed in detail in the Pennsylvania Guardianship Bench Book, Chapter 11, Post-Hearing Proceedings. After an adjudication hearing, the incapacitated person's counsel will remain active on the case as an attorney for the IP. They will be required for any future review hearings, other proceedings, and if additional monitoring actions are ordered by the judge. This could involve assisting the court with reviewing a guardian's report or visiting the incapacitated person, or IP, to make sure they are still safe and in need of a guardian. The attorney might also be asked to assist the court with reviewing the annual report or following up with concerns regarding the IP or guardian. A guardian may also opt to retain their own counsel for the proceedings and for future needs. There are a number of reasons why incapacitated persons with guardians retain legal counsel, as required by Act 61. Court approval is required for expenditures from an incapacitated person's principal. An invasion of principal occurs anytime expenses exceed income for a given reporting period. This is referred to as invasion of principal and is only allowed as indicated in a court order. Sometimes this will be included in the final decree, but any spending of principal not already stipulated in a court order requires prior court approval. Any invasion of principal must be for expenses related to the needs or betterment of the incapacitated person. There are some expenses that require prior court approval, regardless to whether they are paid out of the incapacitated income or the estate's principal. These expenses are gifts, charitable donations, or guardian fees for service. The guardian or the guardian's attorney should ask for these approvals to be included in the final decree or request approval in a subsequent petition. We will discuss gifts in more detail later in this video. Attorneys doing work on behalf of the guardian or the incapacitated person have the right to be compensated. As long as there is enough money received in income, attorney's fees do not have to be pre-approved by the court. If the attorney fees exceed income, then the fees would be considered to be invading principal and will need prior approval. Attorney fees charged to the estate should be reasonable and only for services that directly benefits the guardianship or the needs of the incapacitated person. Attorneys may also be paid for by the county. The rate for services paid for by the county varies by county. If they are being compensated by the county, attorneys should check with the court to determine if they have a set hourly rate or per service fee that is approved. Counties may also offer pro bono opportunities to represent incapacitated persons or guardians in guardianship proceedings or to assist the court in reviewing annual reports. The sale of real estate holdings or other real property of significant value must also be approved by the courts for the safety and oversight of the incapacitated person's estate. Orphans Court Rules 510 to 512 outline the documentation and requirements needed to sell the home of an incapacitated person, with at least 2 competent persons setting forth that they have inspected the property. At least 1 independent appraisal will also be needed to verify the value of the home. If a guardian is unable to continue in their role or failing in their responsibilities to an incapacitated person, the court can be petitioned for their removal. Of course, courts may also initiate this process due to concerns around the guardian's performance of duties or reporting related concerns. Additional reasons to dismiss a guardian include their own incapacity due to disease or illness, they're moving out of the state, or they're being charged or convicted of a crime. If a guardian is removed voluntarily or involuntarily, a successor guardian must then be appointed if no other co-guardians remain on the case, and the court determines the incapacitated person is still in need of a guardian. Guardians of the estate must petition the court for approval to give gifts or make charitable donations from the incapacitated person's or IP's estate, as all funds in the IP's estate are prioritized for their own needs, care, maintenance, and education. Gift giving that is reasonable, given the size of the IP's estate, follows a pattern from the IP's life prior to guardianship, as well as charitable donations which could confer tax benefits. Such gifts are often found to be appropriate, but must still be approved by the court. Any fees related to estate planning for larger estates, such as hiring an accountant, must be pre-approved. This includes services to create an estate plan or to modify an existing plan. The final estate plan must be reviewed and approved by the court. Major health care decisions, for example, end-of-life decision-making, abortion, sterilization, psychosurgery, and more, also require advance approval from the court. While corporations are required to comply with guardianship decrees ordered by the court, unfortunately, issues sometimes arise where banks, hospitals, or other financial or medical institutions do not comply. You may be asked as counsel for the incapacitated person or the guardian to assist with filing petitions to ask the court to subpoena records from a financial or medical institution, or to ask the court to schedule a hearing with the representatives of the institution to understand why the court order is not being satisfied. Contacting the court to request a hearing should always be the last resort if all other communication with the institution has failed. In the event of an IP moving to another state, the guardian should petition the court to transfer the guardianship to the new state where the IP is now residing. The guardian will need to file a new petition in the receiving state, who will then determine if a new guardian will need to be appointed. If the IP is moved to a residence in a different county, the case may be transferred to the court in the county where the IP has moved. The guardian must also notify the court in a reasonable amount of time if they are moving to a new address. If the address is out of state, or to another county in Pennsylvania far away from the IP's residence, the court will determine if the guardian can still continue to satisfy their responsibilities as guardian, such as visiting the IP to check on their well-being if they are guardian of the person. In all of these instances, it is up to the judge whether the case needs to be transferred to another jurisdiction, another state, and if the guardian can continue in their role. Counsel for the guardian may assist the guardian with tasks related to their responsibilities, such as filing annual reports if the need exists and the estate has the means to cover the attorney fees. Remember, if the attorney fees would exceed the IP's income, prior approval by the court will be needed, as this would be considered invasion of principle. Retained counsel must also be mindful of all other legal issues that may arise and the potential need for filing other petitions not necessarily related to the guardianship. They should be maintaining some degree of contact with the client and the client's guardian or other members of the client's care team, as they are able to keep abreast of major issues that might require their assistance, counsel, or expertise. It is important, too, for counsel to learn, recognize, and remain mindful of the differences between their role as counsel and the role of the guardian. Some of the most successful client-attorney relationships hinge on a successful working relationship between the attorney and the client's guardian. These are just some of the reasons why an incapacitated person and their guardian may be represented by counsel post-adjudication. It is important to remember that an attorney's work on a case does not end automatically once the final decree is ordered. We will now take a moment to check in with our fictional attorney cohort at Miller, Jordan, and Wise, Charlie Jordan, and Avery Green. Avery has now been with the firm as a guardianship attorney for just over a year. And Charlie wants to check in with him about post-adjudication practices and responsibilities.
Thanks for your time, Avery. I wanted to check in with you about guardianship post-adjudication practices. You've been here just over a year now. Congratulations. You're doing a good job. I appreciate how diligent you are to the details of your responsibilities, and you balance that self-sufficiency with a good sense of when to check in for assistance with me.
Thank you, Charlie. That means a lot coming from you.
I know you've been keeping in touch with your clients who've retained our services beyond adjudication. How's that going?
One thing that stands out is how, like you've emphasized, each case is different and each client has different needs. That extends into this post-adjudication phase, certainly, too.
That's true. Tell me more about what you've noticed.
Well, I find working with guardians to be interesting because they're all different. I have more of a rapport with some of the professional guardians because I interact with a few of them on behalf of multiple clients. One of my clients had both of her children working as co-guardians, and all the family members were working well together, but they ran into an issue when their bank said they couldn't allow the adult children, both legal guardians, to assist with finances.
Which is obviously incorrect.
Right, of course. So after they still refused to comply, even after I explained the letter of the law to them, they ultimately petitioned the court as the co-guardians. Since their mother is my client, she asked if I could assist if needed, and I offered to help since those were the wishes of my client. I knew the judge would want to know about this non-compliance. They ultimately didn't need my help with the petition, but they kept me in the loop.
Is that the one where the judge held a contempt hearing for the higher-ups at the bank?
Yes. They learned some things about compliance with court orders that day. But from what I hear from the guardians I work with and other guardianship attorneys I interact with here and at court, issues like that come up from time to time with both banks and healthcare providers.
Many bank and hospital staff are informed and know to comply with all court orders. Others seem to have the wrong idea. Education in that area is needed on a consistent and ongoing basis.
Unfortunately, some guardians may not even know to petition the courts for help when these situations arise.
Some do and some don't. Laws and procedures related to guardianship can be confusing for someone that does not work with these types of cases or orders often. Over time, many laws related to guardianship and alternatives to guardianship have evolved, which is a good thing. This just means that all stakeholders working in guardianship must stay vigilant in continuing to educate themselves on best practices.
We all have a lot to learn. I know I have learned and grown in this work much more than I expected to.
As we can see, Charlie has mentored Avery well, and Avery is already showing competence and potential for excellence as a guardianship attorney. There is more detail and nuance involved in post-hearing proceedings than we could cover at Miller, Jordan, and Wise with Charlie and Avery. But to explore the topic a bit more in depth, let's check in with our expert panel.
For me, it's the bring someone back for a review hearing who regained capacity, and to know that basically what we were engaged in guardianship was really out of necessity on a temporary basis, and we were no longer going to need to be involved in the person's life.
I did have a case a number of years ago where a grandson had been appointed for his grandmother as her guardian. She was quite elderly, And it was alleged originally that she'd been financially exploited by some other family members, and the grandson took over. Unfortunately, we learned from Older Adult Protective Services that the grandson began to financially exploit her. So I had to have a review hearing and appoint counsel for her for that hearing to inquire what the grandson was doing and whether he was actually withdrawing funds to meet her needs or for his own needs and exploiting her financially. I did remove him as guardian of her finances after the review hearing, but I didn't really know the facts until I went ahead and had the hearing.
I think, first of all, they ought to read the guardianship handbook that we make available through the AOPC. That's a great starting point. The other as well would be to work with counsel to make sure that you go over the reports and see what categories you're going to need to complete. Another effective way would be to go ahead and develop a budget. I really encourage everyone, develop a budget and bring it to the court for review and approval. That way, if you know what the judge is going to want to see in your budget process, and our reviewers are going to see that, and if the reviewers can say, Judge Myers has already approved these categories of expenses, then you know what you've got to account for. If there are other areas of expenses you don't have to account for, let's go ahead and talk about that as well. That helps to streamline the process, I think, for guardians frequently. Obviously, there are going to be unexpected or sometimes changes in categories of what they have to report, but overall, let's focus on what you really need to do and maybe what you don't need to do. If we can deal with that again right up front, then that leads to a lot of lessened complications down the road.
And to make sure you're aware of the guardianship tracking system where you can file your required annual reports. And to make sure you keep receipts and records on a monthly basis, so that you're prepared and it doesn't become too big a job to make sure you know what's going on financially if you're a financial fiduciary, and what's going on with the person's health care and doctor appointments if you're a guardian of the person. Whichever capacity you're working in, you do need to keep those records and make sure you keep the court apprised of how things are going.
We will now shift from a broad range of post-adjudicatory responsibilities of counsel to a specific post-adjudicatory item of import, the review hearing. Act 61 of 2023, which went into effect in June of 2024, stipulates that anyone adjudicated incapacitated who has the potential to regain capacity must have a review hearing held within the first year after their adjudicatory hearing. This allows, for example, an incapacitated person due to a car accident time to heal and recover. Under these circumstances, the judge is required to schedule the review hearing and include the date in the final decree. Other reasons to conduct review hearings include the possibility of misconduct or negligence on the part of the guardian, the availability of a less restrictive alternative, to add or remove a co-guardian, or if a guardian is voluntarily removing themselves from the case due to not being able to continue in the role. Review hearings can lead to changes in the scope of the guardianship, approve requests by the guardian for certain financial transactions or medical decisions, or the appointment of new guardians in that case. The courts may hold review hearings at the judge's discretion or at the request of the court's guardianship monitor. The guardian, family member, or the IP can request a review hearing with or without counsel filing a petition. We will view the review hearing process through the lens of an Act 61 mandated review hearing coming up for a client of Avery's who has the potential to recover from a head injury that left her incapacitated. This client represents Avery's first experience with a review hearing, and Charlie is offering him mentorship, guidance, and oversight.
Hey, can I check with you about something?
Of course. Come on in.
I just got off the phone with Sal Reynolds, the son of and guardian of the person and estate for our client Myra Reynolds. Her review hearing is coming up next month, and Sal thinks his mom has possibly regained capacity. He said they've discussed what he's noticed a few times in the past several weeks, and Myra is hopeful she might be able to have the guardianship terminated and her rights restored if we can present compelling evidence in the review hearing.
You're going to meet with Myra and try to confirm this for yourself?
I made an appointment to go meet with her next week.
That's a good next step. Assuming Sal is correct and Myra wants to try to get the guardianship terminated, what's your plan?
Simply put, if she wants to end the guardianship, I would do my best to present a case that could result in her getting her wishes.
Remind me of the case?
Car accident, significant head trauma, dramatic and sudden decrease in capacity. No other close family members still living, so the judge assigned Sal because he's willing and a close relative.
And this upcoming review hearing was scheduled in accordance with Act 61 because the doctor testified that there was a chance she could regain capacity, correct?
Yes.
I do remember this one. This is your first review hearing for us on a case you worked solo from the start, isn't it?
It is. I've been here for 13 months now.
Well, that flew by.
Maybe for you.
Okay, so while I know it isn't your client's burden to prove she has regained capacity, you should probably reconnect with the same doctor who testified at the original hearing. That doctor may be able to confirm that they agree with her son's observations, which could bolster your chances at having the guardianship terminated, if those are in fact Myra's wishes. There are some big ifs at play here, but let's imagine ahead a bit and trust Sal for now until you get a chance to meet with her yourself, just as an imaginative exercise. So, if Sal appears to be correct, and if she has regained capacity, and if she does want to try to terminate the guardianship as Sal reports, you have an opportunity to do something really good for her here.
It's exciting. Well, potentially exciting. Sal said that he's been managing her bills with her for the past 3 months, and that each month she is taking on more and more of the actual work and doing a good job with it. He said she's also been starting to do more management of her own calendar. Apparently, lately she has reminded him of upcoming appointments before he can remind her. He's done a good job as his mom's guardian, but I get the feeling he'd rather see her get her rights restored if in fact she has regained capacity.
All of this sounds promising and worth documenting for evidence for the hearing. So, meet with her, note what you notice, be sure to document her wishes, document all of Sal's observations, and good luck.
Will do.
Do you have any other clients who've regained capacity in any way that you're aware of?
No, not that I'm aware.
Well, it's always worth checking. If you ever notice anything of that kind, you can request a review hearing on behalf of the client.
Oh, I know. I check in with all my clients regularly, like my brilliant mentor advised me to.
Well, that's good.
And it's good to be reminded. So thanks.
It's doing pretty well. Good hire, Charlie.
While Avery's client, Myra, appears to have gained capacity, there are other reasons for an attorney to petition for a review hearing on behalf of their client as well, including a less restrictive alternative to guardianship becomes available that could meet the needs of the IP without a guardianship, or the guardian's behavior raises concerns about their fitness for the job. We're going to hear one last time from our experts, this time about the topic of regaining capacity and conducting review hearings.
First would be change of capacity. If the person is declining greatly and they no longer can even be assisted through limited guardianship, then I would say let's talk about maybe beefing up the guardianship authority. On the other hand, if they are recovering capacity, let's see if we can lessen that. Also, I would say a significant change in finances. If they seemingly find themselves being awarded more money through an inheritance or something, if that's going to take more management, let's talk about that in a review hearing. On the other hand, if they've totally dissipated all their assets and there's nothing left to manage, maybe we can reduce the level of guardianship for the estate. And if we can, hopefully that can reduce reporting requirements. These are some of the most common areas where I think there are changes to guardianship. Of course, the other thing too can be the guardian themselves, if there's a guardian. Have their circumstances changed? Are they able to do the job? Do we need to replace the guardian? That's a significant reason to have a review hearing. And finally, I would say too, if they're not timely reporting, is that telling us that something else is going on with the guardian? That's another important reason to have a review hearing.
There's several reasons that a guardian or another family member might request a review hearing. Or, by the way, the incapacitated person himself or herself can also request a review hearing, either directly or through their counsel. The first and probably the most obvious is if they've regained capacity. Someone who has the type of ailment from which they could recover capacity should certainly request a review hearing and request termination of the guardianship if they regain capacity. And other parties, such as the guardian, may also make that request. In addition, review hearings should be requested whenever it's suspected that the guardian or another family member or another person is financially exploiting the individual, neglecting the individual, abusing the individual. Any of those things should be brought to the court's attention so that the court can make sure that there is a qualified and capable guardian in place who's going to make sure they do take all the steps necessary to protect that person.
We had a case where a client and her family came to our office to ask for help accessing some medical supplies that she needed, but also mentioned that the barrier was that she had a guardian, and the guardian wasn't returning her phone calls, and he was also not helping her get these medical supplies she needed. And so once we explored what was going on, we realized that she and her family were trying to work around this guardian who was just not performing their role. And so we ended up requesting a review hearing to review the need for the guardian at all. We had a new evaluation done, which resulted in a finding that she did have capacity. She may have improved from the point where the guardianship first began. There were some language issues, so there were some questions about how accurate it had ever been, but we were able to get the guardianship terminated, and she was then able to start accessing what she needed without having to do this extra work of going around another person when she was supposed to be incapacitated, and just start making her own decisions and being able to do what she wanted to do. And it was a really wonderful experience.
I recently had a review hearing for a person with significant disabilities and some intellectual impairment, at which his counsel advocated that he could sign a power of attorney, a healthcare power of attorney, rather than having a guardian of his person. And so after the hearing, I was able to recognize his healthcare power of attorney rather than the guardianship and dissolve the guardianship of his person.
For me, the most powerful review hearings are where we're able to explain to family members that there's really no longer a need for a guardianship to be in place, that the family has had the ability to basically show to the court that they are managing things so well and they don't need the guardianship for that purpose. The other has been where someone initially was thought to need guardianship. We've appointed a guardian, but they've had the chance then to sit down with an attorney and some other family supports and execute a durable power of attorney, execute an advance directive for health care. And so as a result, we can again alter the guardianship, maybe remove the guardianship. That's happened on a few occasions, and that's a nice thing to be able to do.
I think whenever anyone involved in the guardianship believes that the guardianship could be terminated and is no longer needed, that's an excellent reason for petitioning for a review hearing. Equally, if anyone involved believes that the guardian is exploiting or neglecting the person under their care, that would be an excellent reason to bring it to the court's attention and request a review hearing.
For me, it is knowing that we have someone who is truly following up and looking at the condition of the person. And if changes to guardianship are warranted, let's hold that review hearing and let's make the changes. More observation as opposed to less is better in those situations.
Thank you for your time and attention as we explored these topics together through the scenes with Charlie and Avery, as well as the expert commentaries of the judges and attorneys. If you would like to follow up with the producers of these videos, you are encouraged to do so by emailing oejc@pacourts.us. We hope these videos have helped promote best practices and reminded you of key fundamentals in guardianship-related legal work. One last time, we would like to thank you for your work on behalf of the Pennsylvanians you work with in guardianship matters. Your diligence, professionalism, and compassion make a meaningful difference for people who need advocacy and support. Be well and do good work. Take care.